I have for many years been interested in mediation as a means of resolving disputes. Over 20 years ago, as judge in charge of the commercial court, I issued the first practice direction encouraging the use of mediation in appropriate cases. I have had 50 years' experience in the law as a Queen's Counsel, as chairman of the bar, and for 15 years as a judge of the commercial court. As a judge, I managed the Lloyd's litigation, the largest piece of litigation there has ever been in England and Wales. Between my retirement from the bench and early 2015, I acted as mediator in over 75 mediations with a very high settlement rate. I am now patron of the Society of Mediators. There is far greater use of facilitative mediation as opposed to evaluative mediation. Facilitative mediation should be principled. It should not be a horse trade. Any mediation should have regard to the relevant legal principles. A good definition of mediation is helping parties to have a difficult conversation in secure surroundings with a view to settling their dispute. A mediator seeks to assist the parties to arrive at a settlement from an independent, neutral position. A mediator does not act as a judge or arbitrator or advisor. From my neutral position, I try and assist the parties to work towards a settlement. The procedure at a mediation is for the parties, not the mediator, to determine. Frequently, the parties summarize their main contentions in an opening session and then retire to their private rooms. The mediator visits each room in turn, treating everything said in a private room as confidential, unless instructed to take a message or an offer to the other room. One of the attractions of mediation is its informality and flexibility. Parties can bring business and other matters beyond those raised by the particular dispute into play to resolve the dispute. I do not agree with those who, when training mediators, teach that any well-trained lay mediator can mediate a complicated commercial dispute. Thus, in my opinion, a mediator should not take on a mediation in a banking, insurance, or shipping dispute unless he or she has expertise in and knowledge of banking, insurance, or shipping from a background in the industry or in the relevant fields of law. Parties to such disputes will have no confidence in a mediator who does not know what a letter of credit or a run-off contract or a charter party is. In the commercial court, where I served for 15 years, all judges brought to the court many years of experience at the bar in these fields and in other types of commercial disputes. There are those who say that retired judges do not make good mediators. I disagree. Long experience in the law is a valuable background when helping the parties to understand the risks of litigation. One of the most rewarding uses of mediation is helping parties who wish to do business together to finalize the terms of a complicated commercial contract. Thus, there is a mediation before any dispute arises. It helps parties to do business together. This type of mediation helps promote business. It is a privilege to be instructed to act as a mediator. The role of a mediator is a professional, not a business role. It is elementary that a mediator must show independence, integrity, impartiality, and expertise. It is important to remember that in any mediation, a mediator is concerned with people and their disputes. Those who agree to mediate are entitled to courtesy, expertise, and understanding. The courts seldom provide a perfect solution at an affordable or sensible cost. Time and time again, when mediating, I'm tempted to say, "It's a pity you didn't come and see me before all these costs were incurred." I act as a mediator because I believe in the process. At its best, mediation can be highly constructive. 20 years ago, any suggestion of the use of mediation was novel and to some highly controversial. Today, its uses are taught in schools, universities, and in the workplace. Increased use of mediation is changing the legal landscape.